there are right of appeal available. There can be a first appeal, there can be a second appeal, and there can be a third appeal to High Court, and in some authority, second appeal to tribunal, and substantial question of law to High Court and then to Supreme Court. There are some judgments given, you can read, I'm not going it. There is no inherent right in the taxpayer to withdraw the appeal. Most of us think that the appeal can be withdrawn automatically. The answer is no. You have to move an application. Why do you want to withdraw the appeal? It is for the authority concerned whether the permission is granted to you to withdraw the appeal or not. Because in GST law, especially when there are provisions for enhancing the tax liabilities, including invoking section 73, 74 under section 107. So maybe you have a case where these kind of provisions have to be invoked. Therefore, if the first appellate authority refuses permission to you to withdraw the appeal, this order is also appealable order. So remember, under section 107, any order or decision passed by the proper officer is appealable. So whether it's an order or a decision. So if it's an order that you can, I do not allow you to withdraw the appeal, and if you think you have a right to withdraw the appeal and there are no case made out against you, you can file an appeal in tribunal against that order. So withdrawal of appeal is not automatic. It's a very important thing in GST law. Before you file the appeal, see left, right, and center if there is no other case coming out if you file appeal. Otherwise, tell the assessee, in our view, you should pay the tax. Law applicable at the relevant time is invocable. That is, for example, take the VAT law. Before the provision to make a stay condition mandatory, you have to deposit some money to get the stay. That amendment came on 1st May 2010. Supposing you are dealing with the case of 2008, 2009. In that case, nobody can ask you for a stay amount because at that time, the provision was not there. So what is relevant in what year? Relevant year, the year in which you dispute liability. That is 2008, 2009 or 2017, 18, for example. For example, this 73 limitation extended by 1 year. Supposing they had not extended limitation, the 73 cases, 3 years that expired from the last filing of date of return, therefore they would have become time barred. Right? So you have to be very careful. Before you start drafting the appeal and understanding what's to be done, you have to know in which period it relates to, whether there was an amendment in law prior to that or after that. So law, whether against you or for you, is applicable when you dispute the liability for a particular period. There are Supreme Court judgment you can read. Again, limitation. Whether you're filing a GST, VAT, or any other law, you have to very carefully go through the limitation provisions. And your appeal must be filed. Now, this date of communication, date of service, etc., you have to read the language. Okay, the limitation period is followed by what phrase? For example, it says from date of order. Right? If the date of orders are announced in the open court, it can have a different meaning. But notwithstanding, qua the taxpayer, date of order is held to be date of communication of the order. Now, if the mode of communication is portal, chapter is closed. Like in GST law, they have invoked IT Act section 10. All the provisions applicable for Information Technology Act shall also be applicable to GST law. So, limitation period, when you count from date of order, be careful what is the phrase used in limitation period. And limitation is including condonation. One is limitation period which is given in the Act. So, for example, Income Tax 249, if I want to file an appeal, amended law, 30 days. It's not a sacrosanct. The Commissioner has a power to condone delay, and there is no limitation attached to condone delay. It can be 1 year, 2 years, 30 days, 40 days, whatever. But where there is a limitation attached in law, like GST, they cannot condone delay more than 30 days or 1 month. Then if you go after 4 months, 3 months plus 1 month, your everything is time barred. No court, even the Supreme Court, can grant you delay unless there are compelling reasons. For example, government issues notification कि अभी बहुत बड़ा कोविड है, प्रॉब्लम है, हम लिमिटेशन एक्सटेंड करेंगे. Forget Supreme Court judgment. The state government can also do on their own. In that case, courts can take a view whether limitation period can be condoned or not. Regarding Supreme Court judgment under Article 142, 7th March 20 onwards, it's clear that you can see condonation including the period which was not condonable. That is, the judgment shall also be applicable to the condonation period, not statutory limitation. That is, if the statutory limitation had expired, you still have 30 days of condonation, you can still apply Supreme Court judgment. We will have some judgments here when we touch on this particular topic today. Now, supposing when you file the return, you did not make certain claims and you did not revise the return. I think there's no provision to revise the return. In any case, 3B can't be revised, but rectified. Rectification is possible.
Next month we have you can do it in the next month.
But section 39(9) doesn't allow rectification.
Rectification is the next month.
But it's available, no? Rectification is possible. That's what I'm saying. It's possible. 39(9) permits.
If there are minus figures, then it's a problem.
Okay, you have to pay tax. No, okay, you have to claim refund.
So practically there is no rectification.
Okay, right, right.
It is just the flaw of the system which we are so far
Okay,
exercising.
okay.
Officially, it is not called as rectification.
Now remember, I had given you a judgment if you had read.
No provision under this section.
If I had given you a judgment if you have read ITC versus State of West Bengal. GST law is based on self-assessment. So once you file the return, the self-assessment is complete. If you need to revise the return, make a fresh claim against this order, you file an appeal. You file your own return. It's a self-assessment order. Delhi High Court has also sanctioned this kind of a provision. So if you think that any fresh claim has been left out, you have done some mistake, you have paid more tax or whatever, and you want that money back, then against this, you make an attempt to file an appeal. This is my self-assessment order, and assessment includes, if you read definition of assessment, पढ़ना है इसमें, section 2 में क्या है? Return, yes. About 3 months plus 1 month. I have tried in Karnataka. We had got relief. Huh?
Assessment means determination of tax liability under this act and includes self-assessment.
Yes, includes self-assessment. So once you file the return, that becomes self-assessment order. Therefore, any order or decision covered by section 1071, if there are some issues like this. Otherwise, supposing you want to make a fresh claim now. Let us say you have been subjected to audit or section 61, 2, 3, 65 तक कोई आपकी assessment हो गई, आपने कोई claim raise नहीं किया. Fresh claims can be raised in appeal. There is no bar. Unless the law prohibits specifically that you cannot raise fresh claims.
Suppose if we have not filed an appeal based on self-assessment return and that appeal gets time barred, limitation period
It's over. Then you cannot file the appeal.
then can we have if we have revised the return in the next month or next quarter, will that return
No, but they say revision is not possible. Revision not possible in GST.
not possible? That means our claim is
Gone. Then gone. Then
gone.
this is ITC versus State of West Bengal on a similar law. ITC versus State of Bengal, Supreme Court judgment in 2018. Forget what your client do. We are not bothered about your clients. I'm not bothered to deal with them, but that's the law. If you want to take a relief, it's a Supreme Court judgment. Additional grounds of appeal. When you draft the appeal, be very careful what grounds you have taken. We'll study the checklist. I'm giving you a checklist how to draft appeal. Since Ashok, we are doing basics here. It's not meant for you. If you want to kill your time, it's okay. I'm very happy. We have Mr. Ashok. He's one of the senior lawyers here with us. And thank you for coming, sir. additional grounds of appeal. Supposing you appear before the authority and the authority raises a point, क्या जी आपने ground लिया है? क्या आप argue कर रहे हैं? And if you think that ground was relevant, immediately say, yes, I will move an application for adding a ground of appeal, which will be normally permitted. But do not argue which you have not pleaded. You cannot argue any matter which you have not pleaded where there are no grounds of appeal. Therefore, be careful. You will lose a case if you plead something which is not a part of your grounds of appeal, they will reject. And that rejection will be rightly. And tax authorities up to tribunal, they have all the inherent powers of the assessing authority as well. So we have a tribunal who doesn't understand this at all. He knows nothing about this at all. I can tell him on his face, you know nothing about law. But High Court, Supreme Court says up to tribunal, since he's a final fact-finding authority. So what assessing officer could have done, he can also do. He has the original inherent power of assessing authority. So additional ground of appeal, you have to move an application. Why it is necessary? Along with the additional ground of appeal, you have to enclose the full amended appeal. You can't add one ground. Because what is here is appeal petition, not your ground of additional ground of appeal application. Therefore, amend the entire application and refile it. There is no need to pay stamp duty again because you've already paid the stamp duty. And I'm giving you sufficient Supreme Court rulings in this issue. And a right of appeal is a statutory right. Appeal right is not a fundamental right. It's not given by Constitution of India. Constitution of India says Article 265 that the government can collect tax what is due to it. It stops here. Since it's a statutory right, conditions can be put, like a minimum deposit of 10% of disputed tax or minimum deposit of 20% subject to 25 crore, 50 crore, whatever limitations are before the tribunal. Now, because this is a statutory right given by statute or the limitation part or a particular form to be filed in or a particular set of documents to be attached, all whether mentioned in the substantive law or in rules or in any notification or circular, you have to abide by those laws and procedures before you file the appeal. Because it's a statutory right, it's not a fundamental right. Now, let's go through the checklist quickly. You will get it. I'm just rushing through. Supposing an order comes to you, an order which you have never heard. ये से क्योंकि वो तुम्हारा बंदा डायरेक्टर है, वो चोर है, हम आपका आरसी कैंसिल करते हैं. Let us say this kind of an order comes, and they are capable of giving this kind of order. Such orders are coming. Since out of the two partners, one partner has been declared a chore in GST law, right? Therefore, we de-recognize him. Let us say, I have got one case like this. That's what I'm discussing with you. So now, as a lawyer, as a chartered accountant, you have to understand what is the implication of this order. Does it nullify your partnership? That's the first impact you have to see as a lawyer. Number one. Number two, you have to, in all cases, invariably, even if you are 100% sure, go through the provisions of non-appealable orders. Whether the order which you are attempting to appeal, is it non-appealable? If it is not mentioned in the category of non-appealable orders, then all orders are appealable. Right? For example, I give you a clue. If you go to section 129, detention of vehicle and all that stuff, there are two main provisions, 129 subsection 5 and 129 subsection 9. Supposing अफसर कहता है ये ट्रक छुड़ाना तो पैसे जमा कराओ सारे, रिश्वत के अलावा जो आपको गवर्नमेंट जमा करने हैं, ठीक है? वो कहते हैं जी आपका 5 लाख रुपए बनते हैं, आपने जमा करा दिया. आपने कैसे जमा कराए? Because you were coerced into depositing the money. This is one part. Second part is कि without any discussion with the officer, आपने पैसे अपने चुपचाप जमा करें, हमारा माल छोड़ दो. अब दोनों केस में आपने पैसे जमा कराए. So who can file the appeal? Any person aggrieved with any order or decision passed under this act. Once you suo motu deposit the money, how can you be aggrieved? In this case, section 107 is not available to you. Appeal is not available. You can still file a writ. I deposited under mistake of law. But if They stop your truck and they tell you deposit tax. आपने टैक्स जमा करा दिया, मैटर क्लोज हो गया. It doesn't mean that he doesn't have to pass the order. He still has to pass the order. Because you may like to appeal it. Normally they don't pass orders at all. They say there is no provision in the portal to pass an order. But two high courts have held that no, since you are asking to pay full money tax interest penalty, why should not there be an order to invoke section 107? So you have to be careful. The first thing is you have to examine when a document comes to you whether this is appealable. Notwithstanding at what level practice you do. I may be working in High Court, Supreme Court, whatever court, but still this is the basic you have to go through on your desk, whether this is appealable order, whether appeal is called for. As a good professional, as an ethical professional, this is your job. Under Advocates Act or instead of Chartered Accountants Act, you have to decide whether appeal is called for. Supposing आपने कार खरीदी है, उसका आपने ITC ले लिया, वो नहीं मिलता, अरे कैसे नहीं मिलता, हम ले लेंगे. That is unethical. So you had to, as a professional, you have to guide your client whether appeal is called for or he has to pay. Never get into ठेकेदारी. हम अपील दाखिल करते 10% का स्टे ले लेते हैं सर, 4 साल निकाल देंगे आपके. Then you should be ashamed of yourself if you do this kind of a job. You should hang your head in shame. Because this is very unprofessional. You know something is not available. Something is not available. आपको कैसे ले लेंगे आप? So tell your client कि बड़ी अपील नहीं बनती. हम अपील नहीं करेंगे इसकी. क्लाइंट को पता है कि मेरी 10 लाख की डिमांड है, 1 लाख जमा करा के 9 लाख का कैन डेफर द लायबिलिटी. And this is automatic. And no authority can dismiss the appeal on this ground. Because he still had to hear your merits. It may take 1 year, 2 years, 3 years, we don't know. How much time will it take? Therefore, you have to decide as a professional whether appeal is called for.
So what is the remedy where the officer does not pass an order in spite of our deposit of tax by his oral version? Suppose if he says deposit the tax and he gets a good receipt, and that
Once you immediately file an application, okay, based on directions, we are depositing this money so and so, and you please pass order under section 129(9).
if he doesn't have already
He will have to then writ.
So normally,
फिर High Court writ.
How can he release the vehicle or goods unless he passes an
sir,
order?
he has to give you MO, he has to give you MO
Something he has to write.
something he is always one thing of passing an order or a particular.
No, he is right. He has to pass an order.
Yes.
What is appealable is an order. Right? So any other document is not an order.
He cannot release the goods.
Like DRC 03 is not an order. It's not a show cause notice. They are not passing the order. They are not passing the order.
They are not.
There's a problem. Supposing दिल्ली का ट्रक आप कर्नाटक में पकड़ा गया, अब आप क्या झगड़े करोगे जाके वहां? सपोजिंग 1 लाख रुपए का टैक्स है. ये जो सुप्रीम कोर्ट ने किया है कि ओनली jurisdiction where vehicle is stopped shall have jurisdiction to decide the appeal, वो it will act as a stumbling block for people to file appeals. Appeal lies before which authority? That is also very important. Supposing you are registered under DGST Act, an order is passed by a central officer in your case, then only central level authority has jurisdiction, not local authority. The Supreme Court has laid down with this judgment, if an order is passed under by a particular authority, then all subsequent forums shall be of that act only. Don't jump, अच्छा दिल्ली का है, अरे यार राहुल को बोलते हैं 2 मिनट में हो जाएगा केस. Now supposing you file a wrong appeal. Let us say you were to file an appeal before Special Commissioner Delhi GST. You file before CGST. You must file appeal in time. Now supposing hearing comes after 4 months, after everything is over. ऐसे तो मेरे पास jurisdiction नहीं है, appeal is dismissed as without jurisdiction. You can refile the appeal using Article 14. You approached a wrong forum. Therefore, the time spent with the Special Commissioner CGST can be excluded when you approach the local authority. You have to move an application. आपको ध्यान रखना है, ये गलतियां होंगी बहुत. अभी जो हो रहा है सब बहुत गलतियां होंगी. We are tuned to one particular department. Therefore, अगर आपने वहां 15 दिन में अपील फाइल कर दी थी और 6 महीने बाद डिसाइड करता है कि ईला मैडम ये मेरा तो jurisdiction नहीं है, I want to help you but I can't do it. ये ऑर्डर हमारे डिपार्टमेंट ने पास ही नहीं किया. In that case, you have to refile that appeal before the competent authority using Article 14 for condonation of delay in filing the appeal. Second, next important thing is whether the order which you have before for filing the appeal, whether that person had jurisdiction to do the matter. Supposing you have a case that the refund rejection order can be passed by additional commissioner. Let us say, for example, I don't know kya order hai, and this is passed by a joint commissioner. This order is without jurisdiction. Let's add one more variant. कि joint commissioner ने additional commissioner को approval लिया था. Even then, this is not order of additional commissioner, right? Or supposing you have some other jurisdiction point. हमारे वार्ड वाले करते हैं कभी 1 से लेकर 10 वार्ड का ये फलाना वार्ड नंबर 1 है, तो वार्ड नंबर 2 का वो केस नहीं कर सकता unless he was reappointed as assessing authority for your case by the commissioner or by the government as the case may be.
Which happens very regularly.
तभी दिखा रहे हैं ना, ज्यादा मेहनत करने की जरूरत नहीं, पैसे नहीं कमा सकते ना आप. Now many people think अरे नहीं इसकी अपील फाइल करने की क्या जरूरत है. No, order may be completely illegal, void ab initio. This can be set aside only by the authority prescribed, that is appellate authority. You still have to file the appeal. So jurisdiction issue आपको ध्यान रखना है before you start drafting or studying the appeal part. क्या क्या jurisdiction था. Legal jurisdiction के cases में आप बहुत सारे केस जीत जाते हैं. अगर आपको पता है, आपके पास सारे सर्कुलर है, नोटिफिकेशन है कि क्या क्या jurisdiction लेटेस्ट थे, और jurisdiction उस टाइम का जब का वो ऑर्डर है. Subsequent और prior to that is not relevant. उस पीरियड का क्या jurisdiction इशू था किसी बंदे का, उसी को आपको देखना है क्या ये jurisdiction में केस बनता था या नहीं बनता था, राइट? Whether the order was passed within limitation period. Supposing 73-74 limitation shall expire in Feb 23. February 23 or March? February 23, right? Now supposing you get a case of 73-74 for 17-18, you get an order in March. Dated signed in within limitation, but आपको मिला मार्च या अप्रैल में. Now you have to take a point whether the order is deemed to have been passed within limitation period. Because all orders are to be passed by quoting DIN number and on portal. So any order passed after the limitation date, you can presume this is time barred. Then make an inquiry, how was this order passed? Number one. Number two, I'll ask you a question a little later. Now the order is not simply signed and kept by the officer. Order has to go out of the drawer of the officer so as to be out of his reach, where he can no longer tamper with the order. That is the date of order. That is the date of order qua the taxpayer, qua the assessee. That is the date of order. So जो भी आपको order आता है, if you think it's bordering on limitation, पहली बात तो आपको limitation पता होना चाहिए वो कितने दिन में पास order करना था. अगर आपको वो limitation ही नहीं पता तो आप जो भी कर रहे हैं गलत कर रहे हैं. So this is the kind of checklist you have to go through with every order. Make it a routine. आपको सारा कुछ आता है, doesn't matter. It takes additional 10 minutes. Ask the client for it, no? ये सारी चेकलिस्ट का टिक करके चलो, फिर अपनी अपील ड्राफ्ट करो, उसके बाद अपील में आओ. क्योंकि ये जुरिडिक्शन का इशू है, लिमिटेशन का इशू है, आपको अपील में लिखना है. ये मत लिखना अरे आईटी से कैसे नहीं मिलता, वो दिल्ली हाईकोर्ट की जजमेंट है. The judgment can be reversed by Supreme Court tomorrow. So better to win on jurisdictional issues and technical issues rather than going on merits. कल आपके जो चीफ जस्टिस हैं जो नए आने वाले हैं, उन्होंने बोला litigation is like a bleeding wound. The more you tamper it, the more will you bleed. And that's a very serious statement he made by it कि इस country में इतना litigation है. He made a second statement कि जो गरीब आदमी हैं, they are forced to engage private lawyers. And they sell their houses, sell their everything, but nothing happens to the litigation. So if you can heal the wound without it being bleeding at the threshold, do it. Study it. क्या ये लिमिटेशन में था? अगर टाइम बार्ड है तो आपको दो चीजें करनी है. एक तो उस अथॉरिटी को नोटिस देना है जिसने ऑर्डर पास किया है, दूसरा आपको अपील फाइल, उनको नोटिस जरूर देना है या उसकी अपील की कॉपी सर्व कर दो. कि टाइम बढ़ डोंट प्रोसीड विद. अब जहां इश्यू आएगा व्हाट अबाउट 10%, you will have to deposit 10%. But this is fit case to go to high court because this is without jurisdiction. But if your client doesn't want to go to high court for ABC reason, then you cannot file the appeal till you deposit 10% of the demand raised. Then if tax interest penalty has been computed, and nowadays on GST portal, I don't know what they do, but if it's correct, it's okay. But still sometimes you should recheck whether the interest has been rightly calculated. अब पोर्टल पे आता है सब कुछ ये. Okay. Now, once you call the client and tell him कि क्या क्या हुआ बता, supposing you have a fresh case, assessment was not done by you like we people do. We ask the client तेरे क्या claim थे? वो कहते हैं मेरा गुड्स रिटर्न का क्लेम था, ये इन्होंने मेरे से मेरी सर्विस थी, मेरे गुड्स पे टैक्स कर दिया, ये कर दिया, वो कर दिया जो आपके रिटर्न में नहीं था. इन अपील रेज फ्रेश प्ली एंड अपील में लिखो, आई विल टेल यू व्हाट टू राइट. अपील में लिखो कि दीज फॉलोइंग ग्राउंड्स आर फ्रेश प्लीज व्हिच वर नॉट टेकन बिफोर असेसिंग अथॉरिटी एंड देयरफॉर मूव एन एप्लीकेशन कि दीज एडिशनल ग्राउंड्स बी अलाउड. ये आपको अपील में लिखना है, राइट? कि जो एग्जिस्टिंग ग्राउंड पे कैप जब आप ब्रीफ एक्ट बनाते हैं उसमें लिखते हैं टैक्स क्यों लगा. अब जिन चीजों पे आपको टैक्स नहीं देना था उसने लगाया था, या आपने गलती से दिया, जो भी आपने किया, देन राइट दीज आर फ्रेश प्लीज. फ्रेश प्लीज कैन बी ऑफ टू टाइप्स. वन इज द फ्रेश प्ली बेस्ड ऑन फैक्ट्स, जो फैक्ट्स आपके केस के हैं. सेकेंड कुड बी मिस्टेक ऑफ लॉ under section 73 Contract Act. This is allowed even for tax cases. Supreme Court has held in many cases. Third is a subsequent judgment of jurisdictional high court or Supreme Court. All three are invocable to raise fresh pleas and fresh grounds of appeal. ये आपको अपील में देखना है. जब तक आप उस ऑर्डर को पढ़ोगे नहीं, क्लाइंट को बुलाओगे नहीं, whatever you do is rubbish. If you want to be a cut above the rest, take 50,000 instead of 5,000. ये 45,000 कमाने के लिए आपको ये एक्स्ट्रा काम करना है. वही 2-5,000 रुपए, 5,000 रिश्वत, 5,000 फीस, खत्म बात. You want to be a cut above the rest, walk an extra mile. Examine. और आपको बहुत सारे केसेस मिलेंगे, हर केस में गलतियां मिलेंगी आपको. हर Ocean Fate, for example. A live example. Supreme Court says not imposable. Supposing आपने पे किया और अपने आईटी से नहीं लिया, you have to claim the refund. Limitation is 2 years from date of Supreme Court judgment. Now this is a ground for fresh plea. Supposing Delhi High Court says ये फलां government service is exempt from tax, and you have paid tax, and your contract was inclusive of tax, that is another ground to take the money back. मिलेगा नहीं मिलेगा हमें नहीं पता. But question is, when you draft the appeal, you must raise this fresh pleas. Give a heading, fresh grounds, fresh plea, or whatever language you want to use there, so that the appellate authority is clear कि ये ground assessment में नहीं थे, and along with application for additional pleas. अभी आएंगे, उस पर भी आएंगे. डॉक्यूमेंट क्या लगाने हैं आपको. ये क्लास फ्रेशर्स के लिए है, तुम्हारे लिए नहीं है. हमारे यहाँ से बुड्ढों के लिए नहीं है. हाँ, ये फ्रेशर हो तुम. अशोक भी फ्रेशर बोलेगा, उसका 45 साल हो गए लिटिगेशन करते हुए. हम उनसे सीखते हैं, वो यहाँ है. वाइडेस्ट पॉसिबल ग्राउंड्स, जो ग्राउंड बिल्कुल आपके व्यू में अनटेनेबल हैं बट पॉसिबल हैं, टेक दिस. द ग्राउंड विच यू डोंट टेक, यू कांट प्लीड. पेनल्टी पे 4-5 ग्राउंड हो सकते हैं बिना नोटिस के. है सेक्शन की रिक्वायरमेंट पूरी नहीं होती जी, हमें ये पेनल्टी कितना अमाउंट नहीं बनता. इस तरह की चीजें आप पेनल्टी के आप 4 ग्राउंड बन सकते हैं. आप टैक्स कीजिए, इससे एंट्री नहीं लिखी, इससे आइटम कवर होती है, इसमें नहीं होती. फॉर एग्जांपल इंडियन कत्था, आई गिव यू वन एग्जांपल, वी रिसेंटली गिवन ओपिनियन. ये शेड्यूल 1 में भी है, शेड्यूल 2 में भी है. शेड्यूल 1 says tax free, then says schedule say 5%. I was called upon to give an opinion. What is this? I said don't pay. let them go to court. Even though there is a Supreme Court judgment, notification ambiguity will be resolved in favor of revenue, not in favor of taxpayers. This case is Sunrise Exports versus Commissioner Excise, 2020.
It was otherwise.
Previously it was otherwise, yes. We said don't pay. Let them fight it out. We'll fight it out. Though we told them that this is the correct law, but we would say you pay it off. This is a debatable issue. You can always take an alternative plea. For example, you are sure that this penalty has been imposed in violation of High Court ruling of Bansal Dye Chemical. Without notice, penalty cannot be levied. Right? So what is your prayer? That this penalty is vowed ab initio as has been levied in violation of Delhi High Court ruling, where pre-penalty notice was mandatory. However, alternative plea, we say that the authority be directed to levy penalty after giving due process of law. Now, supposing your prayer is one, and the kind of Supreme Court tribunal we have here, you say, I don't agree with Bansal Dye, your case is gone. Here also it will require an amendment in your appeal to add a fresh prayer. So alternative plea is a tool of a lawyer or a professional. You must know how to do it. Is it Delhi High Court judgment? Tomorrow Supreme Court can quash. Supposing they had filed SLP in Supreme Court. It doesn't matter. Even if it's state, it still doesn't matter. Judgment is still binding. But what will happen Supreme Court tomorrow, you don't know. So learn to take alternative plea if you want. जो हम अपील के ग्राउंड्स बनाते हैं, दे शुड बी क्रिस्प, लंबे लंबे नहीं. नीचे केस लॉ आप कोट कर सकते हो, बट इट शुड बी 4-5 लाइन्स. For example, on the issue of penalty, the appellant says and submits that the penalty under so and so section, you have to quote section, and the subsection has been levied without issues of mandatory notice, right? And the section itself requires a procedure being heard. Therefore, this penalty is not leviable. In support of it, I quote the following judgments. So your ground is 4-line, right? For example, you say the taxpayer has applied the HSN code number so and so. However, this HSN code is not applicable to our case because of the following reasons. One more ground. Third, the order was passed on a holiday. I see no bar why orders can't be passed on holidays. But most of the high courts have held that the order should be passed on working days. Supposing government says because of COVID issues, the government department will work 30 days a week, 30 days a month. So the Sunday is a working day, declared working day. Depends on facts to facts. So you write this. Or suppose you write that the appeal has been dismissed as time barred, whereas it should not have been dismissed time barred for the following reason. तो जो आपके जो बेसिक ग्राउंड्स हैं, अगर उसमें हम इसको आर्गुमेंट ऐड करेंगे तो ग्राउंड्स का इंपैक्ट खत्म हो जाता है. You have to be brief, but give case law which is relevant, 1, 2, 3 judgments. Judgment quote करके para quote करो. If it's not a very long judgment, annex the judgment with it. Right? Statement of facts. If you do not master the facts, your appeal has no meaning. Your ground of appeal shall emanate from the brief facts you narrate. ब्रीफ फैक्ट आपके 2 पेज के भी हो सकते हैं, 10 पेज के भी हो सकते हैं, आधे पेज के भी हो सकते हैं. इट्स नॉट अ सिनॉप्सिस. सो व्हाट इज अ ब्रीफ फैक्ट? You should know who can file appeal. Any person aggrieved, not registered taxpayer. But she'll write in brief fact, yes, so and so, I'm holding GST number. I filed all my returns. There is no tax admitted which is due, and the appeal has been filed within limitation period. So, क्या jurisdiction है? अपील आप फाइल कर सकते हो, ऑर्डर डिसीजन वापस है, आपको 3 महीने फाइल आपने की है, और आपको अगर कोई टैक्स एडमिटेड है व्हिच यू हैव नॉट पेड विद रिटर्न, यू हैव टू पे विद इनकम टैक्स और सेल्स टैक्स, दोनों में आपको पेमेंट करनी है. यू से देयर इज नो एडमिट टैक्स व्हिच आई हैव नॉट पेड. एक पैरा आपका खत्म हो गया. सेकंड, व्हाट यू डू. फॉर एग्जांपल यू आर ए ट्रांसपोर्टर, तो जो आप ट्रक खरीदते हैं, बसें खरीदते हैं, आपको आईटीसी मिलता है. सपोजिंग यू आर रेस्टोरेंट ओनर, इट्स डिबेटेबल वेदर यू विल गेट इट और नॉट. So all these GST number, DIN number तो ऊपर लिखते हैं आप. Demands have been raised, tax, interest, penalty. तीनों का हेडिंग है कि टोटल करो. the demands have been raised on the following grounds. जैसे सर गलत था, पेनल्टी लगा दी, इंटरेस्ट लगा दिया, मेरे क्लेम रिजेक्ट कर दिया, आईटीसी रिजेक्ट कर दिए, मेरे को कोई ट्रांसपोर्टर का इशू बन गया, कोई मेरे E1 फॉल, जो भी उसने किया उसके एक एक पॉइंट करके लिखो, the only following cases on the following ground demand has been raised. Then write next para. I am aggrieved with this order, therefore I am filing this appeal under section 1071 or 1072 before your honor to seek justice and fair play on the following grounds of appeal. Then take up grounds of appeal. Grounds of appeal mein it is avoidable to quote provisions. But once you quote a provision on a ground of appeal, then your relief gets restricted to that ground, that provision. There may be many other provisions. The scheme of the act may suggest कि आपको relief मिलना चाहिए. Therefore, yes, for example, ocean freight, before Supreme Court judgment. In our view, ocean freight is not taxable because it is a composite service, and therefore the importer cannot be deemed to be a recipient of service. Exporter cannot be deemed to be a recipient of service. Or for example, आपका बस का ITC नहीं मिला. You can say I'm entitled to the credit of purchase of bus in view of section so and so. हाँ लिखना है, तो 13% अंदर ऊपर है, 14 ये हैं वो हैं, उसकी थोड़ी हिस्ट्री लिखो, तो नीचे सारे ग्राउंड्स लिखो, then write prayer. जिन 6 ग्राउंड पे आपको टैक्स लगा है, as you think all should go, you have to write 6 prayers, not 1. 6 prayers. The tax on ocean freight should be quashed, so and so. Interest should be quashed. ITC should be allowed on bus or whatever. इस तरह की जो भी चीजें हैं आपको 6 प्रेयर लिखने हैं. Against each point raised by assessing authority, if you have a case against that is in your favor, then you mention all the 6 prayers in the prayer clause without quoting any section or nothing. वो आप आर्गुमेंट में जो मर्जी करो, अपील में नहीं लिखना, because then your prayer gets restricted to a particular provision. All of what expert पे सारे सब क्लॉज A B C D पता है. हम जनरल लिखेंगे जी मैं ITC मिलता है, सेक्शन 17 में इसकी बाहर नहीं है. Is always better. Open ended is always better. Then at the end, you should write any other order or decision as this court may deem fit and proper circumstances may also be passed in favor. This is the way you have to type your brief facts and grounds of appeal. 19 लोगों ने अपील भेजी थी, and most of them have done very well. अगर आपने वो खुद लिखा था, 1-2 लोगों को तो मैं खुद नहीं लिखा था, आई एम वेरी श्योर, लेकिन जब ने बाकी लिखा था, दिस गुड. Who has to file and sign the appeal? You have to go into rules. Who's authorized this? Like income tax, for example. उसमें पूरी लंबी लिस्ट है, HUF है, ये है, वो सारा. हमारे यहाँ नहीं है ऐसा, right? But appeal can be filed by authorized signatory only. But if the appeal provision PMLA requires a director to sign the appeal or a party to sign the appeal, then you can sign the appeal even if you have the power of attorney, which is private. The Supreme Court says the property cannot be sold on based on power of attorney. It has no meaning. अभी लास्ट वीक सुप्रीम कोर्ट ने दोबारा बोला है कि पावर अटॉर्नी भी कोई सेल डीड नहीं हो सकती. बात खत्म. एक तो स्टैंप ड्यूटी दो, ये किसकी पावर अटॉर्नी, किसी ने कौन सी साइन मार के साइन करा ली, किसी को क्या पता. So therefore they say it cannot be done. So who has to sign the appeal? Lawyer, chartered accountant cannot sign the appeal under any circumstances. You cannot be a privy to facts of the case. It's not your case. You will never sign ever. It become time barred, let it become time barred. Now supposing the assessee is away out of India and only he has to file the appeal. Then you have to tell him, sir, sign the appeal and take a certificate from that particular country's Indian High Commission and sign the appeal. If law requires so. Or file the appeal by a second person in the company and move an application, because this is a curable defect. This defect will not affect the limitation part. अगर आपने 3 महीने में अपील फाइल कर दिया, किसी और ने साइन की है, and the objection raised by the government counsel, this appeal is not signed by Mr. Verma. It's a curable defect. This defect can be allowed to be cured by the appellate authority. But appeal before you file the appeal, it should be signed by the person who is authorized in law to sign. Who will be the respondent? हम सीधा लिखते हैं कमिश्नर. He has to be respondent in any case. लेकिन अगर कुछ पार्टियों को आपने और respondent बनाना है, if law prohibits, only commissioner will be respondent, then you have to seek permission of the court to make any other party a respondent. अगर ये ऐसा नहीं लिखा है and you want to make somebody else also a respondent, then make him a respondent. Let the government council object. Fight it out. Say for example, tax कर दिया, and you want to examine that of, he's the third person. That officer is the third party in your particular matter. You have a right to examine him. Kalra Glue Factory versus CSS Commissioner. It's a Supreme Court judgment of 1 page. We have this here today. In that, Supreme Court said, if you are relying on a statement of a third party, the assessee has the right to cross-examine him. So, अगर कोई आपका ऐसा केस है तो उसको पार्टी बनाओ. Let the authority object, वो अगला कीजिए. आपने पार्टी बना के अपील फाइल करनी है, उसमें कॉपी पहले सर्व कर दो. He cannot say no. Let him go to court. How can I be a party? Let him debate it out. But you do your duty. कि अगर 4 पार्टियां आपको बनानी है जो बनती हैं, फॉर एग्जाम्पल दिल्ली में भी पीछे कैसे कोई आरसी कैंसिल का झगड़ा था, हमारे मतदान साहब प्रेसिडेंट थे, उनका कोई झगड़ा था, 2 पार्टनर्स के झगड़े थे, सॉर्ट आउट हो गया. And I told him file a return, make both of them parties. ये झगड़ा किस बात का, फंड तो मेरी है, माल मेरा है. सो रिस्पोंडेंट जिसको बनाना है वो भी आपको डिसाइड करना है when you file the appeal. Application for stay. GST में stay का मतलब नहीं, deposit 10%, entire thing is deemed to have been stayed. Now supposing there is no demand, the first arbiter authority gives a direction, इसका आरसी कैंसिल कर दो. He has a power. अब आपको इसकी अपील करनी है ट्रिब्यूनल में. हम रूटीन में क्या करते हैं, अपील फाइल कर देते हैं. In the meantime, your RC is cancelled. Appeal becomes unfructuous. Therefore, when you go to tribunal, make a prayer, stay the operation of order of these lower authorities, giving direction that my RC should be cancelled, dispose of my appeal on merits as early as possible. If you do not seek a stay, whether tribunal can give a stay or not, that's immaterial. You must move an application. आ जाएगा अभी 2 महीने की बात है, 2-3 महीने में you will have a tribunal. मोदी साहब को इलेक्शन जीतना है तो वो ट्रिब्यूनल लाना पड़ेगा, नीचे वाले लोग पूरे व्यापार को वैसे खत्म कर देंगे. So therefore, you have to move an application before tribunal. Okay, these are the facts of my case. If this order of the special commission is not stayed, my RC may be cancelled, my appeal may become unfructuous. Therefore, in the interest of justice, the order of the lower authorities, there should be interim stay till disposal of the appeal, ताकि आपका आरसी की होप सर्वाइव. और ऐसे कई सारे और भी केसेस हो सकते हैं. Say for example, income tax. There are 2 cases. When you don't file the return, the commission has the power to exempt. तो वहां पर अगर स्टे एप्लीकेशन मूव नहीं करते असेसिंग ऑफिसर के आगे तो क्या करेंगे आप? रिकवरी आपका बैंक में अटैच हो जाएगा 30 दिन के बाद. Because you are bound to move an application before the jurisdictional ward officer for stay, copy to commissioner. So you have to decide whether stay is required or not. If it's only a demand, you deposit 10%, there's no need. If it's not a demand, there are some other issues, then you have to move. Then last, a very, very important question. बिना शोकाज नोटिस में आपको जीएसटी में टैक्स नहीं लग सकता, आपका आरसी कैंसिल नहीं हो सकता. हर चीज में एक नोटिस चाहिए आपको, जो शोकाज हो या नोटिस हो. जो ग्राउंड्स नोटिस में लिखे गए हैं उन्हीं ग्राउंड्स के ऊपर ही असेसिंग ऑफिसर एक्शन ले सकता है. ही कैन नॉट इन्वेंट ए न्यू ग्राउंड टू डिनाई यू रिलीफ. Now, this is again a job of a professional when you go into litigation. वो कहते हैं अब बंदा आया, इला जी मेरा आरसी कैंसिल हो गया, ठीक हो जाएगा, हाँ हो जाएगा, लो पैसे लाओ. किस बात के पैसे भाई, पढ़ लो क्या लिखा है. तो उसको बोलो भाई और पेपर क्या आपके पास? बस ये हमारे पास तो ऑर्डर आया, बस और तो कुछ है. सब यही बोलते हैं ना, हमें पता नहीं ईमेल में यही आया और तो कुछ है नहीं. आप ईमेल कभी देखी नहीं होगी अपनी आज तक. That is your job to ensure you go through this portal and see what is the show cause notice. जो ग्राउंड शो कास्ट नोटिस में नहीं था, the officer or the proper officer has no jurisdiction to travel beyond that notice and deny you relief. And this will be a dominant ground that this order is without jurisdiction because he never assumed a jurisdiction on the ground on which he had denied the relief. तो शोकाज नोटिस का आपने क्या रिप्लाई किया, क्या नहीं किया, वो आपको देखना है. दैट इज शोकाज नोटिस आपने रिप्लाई फाइल कर दिया किया था, देन योर अपील इज टोटली डिफरेंट. अगर वो ग्राउंड्स आपको शोकाज नोटिस में कन्फ्रंट ही नहीं किए गए, then your appeal is totally different. It can be a case of high court writ also. And most of the writs on this sort notice by high courts have been allowed. Right? So this is the checklist. पारुल कर देंगे आप सबको? आप राहुल कर दिया आपने? Okay. नहीं, आप अभी तो पहले फर्स्ट अथॉरिटी है ना, हाँ तो उनको करोगे. अपील तो उसको ही करनी है, आपको अपील करनी है तो ट्रिब्यूनल नहीं जा सकते, हाई कोर्ट जा सकते हो. इफ द ऑर्डर विदाउट जुरिडिक्शन इट्स इन ग्रॉस वायलेशन ऑफ नेचुरल जस्टिस और इट्स बीन पास वायलेशन ए सुप्रीम कोर्ट और ए जुरिडिक्शनल हाई कोर्ट जजमेंट. At the main ground can approach high court under article 226 or 227. No, cannot.
अपील में फिर कैसे जाए? ऑर्डर इशू नहीं.
हाँ तो फिर जब नो अपील, देयर नो ऑर्डर पास्ड.
तो सर क्लाइंट का मतलब
फिर क्लाइंट हम रोए, तुम भी रो, वो भी रोए, फिर आप क्या कर सकते हो? एज ए लॉयर डोंट टेक इट पर्सनल. इट्स नॉट योर क्लाइंट टू गो टू हेल. अब अफसर ऑर्डर पास नहीं करेगा, आपको स्ट्रेस ले रहे हो, उसके खिलाफ कुछ हो गया तो मसला होना यार. 2930 बात कर रहे हो, सेक्शन 2930 की बात कर रहे हो ना आप. ओके. नाउ हाउ डू यू प्रिपेयर द अपील? ये तो सारे जो 14 पॉइंट थे अपील करने से पहले आपको देखने कि अपील आपको बनानी क्या है. नाउ देयर इज अनदर चेकलिस्ट. व्हाट इज द पर्पस ऑफ अपील? टिल यू टॉक टू योर क्लाइंट यू कैन नॉट डिसाइड द पर्पस. क्लाइंट क्या चाहता है? मैंने आपको शुरू में डिस्कशन में बोला था, मेरे पास एक केस आया, मैंने कहा नहीं यार जो डिमांड गलत है, सेंट्रल में तो पूरी डिमांड गलत है. वो कहता है जी अपील हमारे पास रिफॉर्म नहीं है, हमने यहाँ से रिलीफ ले रखा है. तो क्लाइंट कहता नहीं किसकी अपील नहीं, टैक्स जमा करा देंगे. हमारे पास सी फॉर्म ही नहीं थे, हमने लिखवा लिया कि सी फॉर्म. सो टू टेक अ लीगल इंटरप्रिटेशन फॉर योर फ्यूचर कोर्स. जो टैक्स डिमांड के ग्राउंड अलग है, लीगल इंटरप्रिटेशन यू हैव टू गो टू इंटरप्रिटेशन ऑफ स्टैट्यूट्स कि कौन सा रूल वहां लागू होगा. एचएस है बेसिकली. सल डाई केमिकल में सेल टैक्स बार का जो पॉइंट नहीं लिया गया डेली है जजमेंट. देयर एज ए शुड बी बोल्ड एनफ टू से यू नहीं करना पड़ता है, करना कैसे नहीं पड़ता है. I'll tell you in the open trial. So 26 I'll tell you this. I mean, I'm sure he has not read the judgment. Mr. Narendra Kumar Jindal doesn't read the judgments. He just reads 4 lines here and there कि मैंने रिलीफ देना है, नहीं देना, रिमांड करना है. He doesn't know the meaning of